So I have a very important update in a suppressor freedom lawsuit, which aims to remove a state outright ban on the purchase and possession of suppressors. So let's talk about what's happening in this interesting case. Now, really quick before we jump into this video, I just wanted to wish everybody a Merry Christmas. I hope you and your family had an amazing time during Christmas. I hope you got to enjoy your time with your family and got to really just focus on the whole purpose of Christmas. And I also just wanted to mention that looking at some of my analytics, about 60% of all my viewers are actually not subscribed to the channel. So if you want to give me a free Christmas gift, if you want to support the channel, please consider subscribing to the channel. Also click the notification bell and turn on all notifications because that helps to ensure that you will actually get these videos when I release them. As I mentioned in the intro, in this video, I have a very interesting update for you in one of the lawsuits, which aims to remove a statewide ban on the purchase and possession of suppressors. Now, this case comes out of the state of Illinois. This is a federal lawsuit, and it's a case called Morse versus Raoul. This lawsuit is critical because it could be the first in the nation which finds that a state's outright ban on NFA items is actually unconstitutional. This will also likely be a case that has major implications for other states that have, restrictions on NFA items like SBRs and suppressors, states like California that have very similar laws that are in place. Currently in this case, the state of Illinois is trying to have the entire case completely thrown out by arguing that suppressors are not arms and therefore they are not protected at all by the text of the Second Amendment. The state of Illinois is currently requesting that the judge here in this case grant a judgment on the pleadings, and they grant that in the state's favor and throw the entire case out right here and now. Now, this suppressor case was temporarily on hold until Judge McGlynn issued his ruling and decision in a similar case coming out of Illinois, and it dealt with the Illinois PICA case. That was the rifle and magazine ban that the state of Illinois had put in place. Well, recently, Judge McGlynn did issue his decision, and he struck down the entire Illinois rifle and magazine ban. And now the suppressor lawsuit case, which was on hold, is now once again moving forward because of that decision. The state of Illinois recently asked for the court here, the judge here who is reviewing the judgment on the pleadings, to take notice of a Fourth Circuit decision which was similar in nature, and it held that suppressors are not arms within the meaning of the text of the Second Amendment and that they are not needed for the function of a firearm. The state of Illinois is now trying to use that incorrect and unpublished opinion, which is out of the Fourth Circuit, as additional support for why their statewide suppressor ban is constitutional. Now, the judge in the suppressor case has accepted that additional case and will consider it for the purposes of the judgment on the pleadings. So we need to talk about what that other case out of the Fourth Circuit said about suppressors and what it's going to do for this specific challenge against the state of Illinois' outright ban on suppressors. Now, in this case, the plaintiffs argued that suppressors are not dangerous and unusual, and that the mere ownership of a suppressor cannot constitute the ownership of a dangerous and unusual item. Instead, they argue these are common arms owned by law-abiding people for lawful purposes. In their motion, Illinois argues that the Second Amendment protects only the right of people to keep and bear arms. Silencers are not weapons. They are not used for self-defense, and they are not necessary for the effective use of a firearm. So they are not arms within the meaning of the constitutional text, and thus plaintiffs cannot prevail on their Second Amendment claim. The state goes on to argue that while an instrument need not have existed at the time of the founding to fall within the amendment's ambit, it still must fit the founding era definition of an arm. But a silencer is not itself used to cast at or strike another. It does not contain, feed, or project ammunition, and it does not serve any intrinsic self-defense purpose. And while some people find silencers useful, they are not so critical to firearms ownership that firearms cannot be used effectively without them. Silencers are not therefore arms within the original meaning of the constitutional text. So that is what the state of Illinois is arguing. They also went on to state that silencers do not satisfy this definition of arms. A silencer is a firearm accessory. It's not a weapon in itself, nor is it an armor of defense. So the state of Illinois' primary argument is that a suppressor in its own right is not an arm. It doesn't shoot a projectile. It doesn't, cast or strike at someone else, and therefore it's not protected. They claim that only actual firearms can be considered arms and therefore protected. They believe a suppressor is simply an accessory at best and again is not protected. Now, of course, that contradicts the fact that under federal law, these type of items, these suppressors are actually treated as firearms under the NFA, but the state of Illinois wants to ignore that. Now, like I mentioned, this case was recently stayed, and the decision for the motion to dismiss for judgment on the pleadings was also stayed by that judge because they believe the Illinois PICA case and that decision there could actually impact the outcome of the suppressor lawsuit. The judge in this suppressor case wanted to see maybe how another lower court applied the Seventh Circuit's recent decision on the whole rifle and magazine ban. Also within PICA, there are restrictions on various characteristics and accessories like flash suppressors, threaded barrels, magazines, and other things like that. So it could also implicate and kind of impact how the analysis works for suppressors. Like I mentioned, recently Judge McGlynn did issue his decision striking down all of PICA, and now that has been appealed up to the 7th Circuit. But because of that, the plaintiffs in the suppressor case have also submitted that PICA decision to the court here, saying that you should now deny the judgment on the pleadings, because in the similar PICA case, they found that all of those accessory restrictions, all of those characteristic restrictions were a violation of the Second Amendment. In the same way, a suppressor restriction should also be a violation of the Second Amendment. So the plaintiffs submitted their supplemental brief in a supplemental case, directly out of Illinois dealing with the PICA challenge. But now the state of Illinois has submitted their own supplemental notice of a related case, and it involves an unpublished Fourth Circuit decision. In this case, the Fourth Circuit determined that suppressors are not arms for the purpose of the Second Amendment, and that they are not required for the operation of a firearm. In the case, an individual, Mr. Salim, was charged with illegally possessing an SBR and a suppressor. He challenged his convictions under the new Bruin analysis, but on review, the federal district court dismissed his challenge, finding that these items were not protected under the Second Amendment. He appealed that decision up to the Fourth Circuit Court of Appeals, but on review, the Fourth Circuit upheld that lower court decision. The Fourth Circuit actually stated in their opinion that nothing in Bruin abrogated Heller's extensive discussion of the contours of the scope of the right enshrined in the Second Amendment. Accordingly, Miller stood for the proposition that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes. Therefore, Mr. Salim's possession of a short-barreled shotgun is not protected by the Second Amendment. With respect to the second challenge regulation concerning silencers, Salim contends that silencers are considered arms that fall within the scope of the Second Amendment protection, or if they're not arms, they are reasonably necessary accoutrements. We disagree, the Fourth Circuit said. The Supreme Court in Heller defined arms as anything that a man wears for his defense, or takes into his hand, or uses in wrath to cast or strike at another. Therefore, the Second Amendment extends to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. While a silencer may be a firearm accessory, it is not a bearable arm that is capable of casting a bullet. Moreover, while silencers may serve a safety purpose to dampen sounds and protect the hearing of a firearm user or nearby bystanders, it fails to serve a core purpose in the arm's function. A firearm will still be useful and function without a silencer. And a silencer is not a key item for the arm's upkeep and use like cleaning materials and bullets. Thus, a silencer does not fall within the scope of the Second Amendment's protection. The district court therefore properly denied Salim's motion to dismiss the indictment based on Bruin. So that was the Fourth Circuit's decision in the Salim case that is now being used as support in this Illinois suppressor challenge. The state of Illinois points out that this unpublished opinion in the Fourth Circuit is not binding on this court here, but they are saying it's very similar, dealt with a similar issue, and therefore this court here in Illinois should use it to actually rule on the judgment on the pleadings. The state argues that a firearm will still be useful and functional without a silencer attached, and a silencer is not a key item for the arm's upkeep and use like cleaning materials and bullets, which is very interesting because they're almost saying that cleaning materials of firearms are almost more protected than a suppressor or a silencer, which is a very interesting position to take. Now, the court here in this Illinois suppressor case has allowed this additional supplemental case. So this is a very interesting development. On the one hand, you have the plaintiffs here, which are using the rifle and magazine ban, which deals with the Illinois PICA case and that recent decision, which struck down all of PICA. They're using that for their support for why the judgment on the pleadings should be denied. And then on the other hand, you have the state of Illinois, which is using the Fourth Circuit suppressor and SBR and short-barreled shotgun decision as support for why they should actually win on their request for a judgment on the pleadings. So a very interesting development. We're going to be waiting to see how this plays out. It's going to be interesting to see which way the court leans. Are they going to lean in favor of the plaintiffs, striking down this Illinois suppressor law, or are they going to lean in the favor of the state of Illinois and once again find, kind of like the Fourth Circuit, that suppressors are not protected arms? So as we get more information, as things develop, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you guys for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.